So, welcome to the latest legal work group call. We've been having these around once a month for the last few months, and we've made some substantial progress on model provisions to help with procurement. Before we dive into the meeting, I'm just showing our antitrust policy notice. We show this at the beginning of every Linux Foundation meeting. The full antitrust policy is on the website cited in the slides. If you're from a Linux Foundation member company, you can direct any questions to Andy Updegrove, the counsel responsible for this. Now, moving into what we're doing, we've been busy here basically exploring how model provisions for OpenChain ISO 5230 or ISO DIS 18974 can be provided as examples for procurement contracts or similar material. Now, instead of starting from scratch, we decided to begin our mental modeling around an older document called the risk grid. That document is, I believe, 14 years old or so now, maybe 15. It was originated by some of the people who are very much involved in this group. Notably, of course, Malcolm Bain in Spain, I believe, was the first author of this. Andrew Katz, as well, a significant contributor, Carlo Piana, and so on. Many over the years, it has been solid. So we sat down and said, how do we start from here? And we started building our model provisions on GitHub. Now, what I'm going to do to get us started is to drop you the link of our model provisions on GitHub. So you have access to that if you so wish. And I'll also throw the link into the chat for the risk grid if you want to have a look at that. Now, as it happens, we were beginning to look at pretty much mirroring the risk grid. And then along came Andrew with some fantastic ideas and material from Moorcroft and Orcrow. And he basically did 98% of the hard work for us on pulling this together. The last call, we got to essentially the fourth major revision of the document. And we're now on the fifth, where Andrew has yet again contributed more material, which might have pulled it together and allow us to go and pretty much publish the document very soon. I've put the direct link to this in the chat. Now, there's a couple of things to do on this call. If it's okay with Andrew, I'll ask him to talk through the changes that he's introduced.
Yep.
I'd also like to make one or two suggestions myself. One is we have some material at the end of our document, which is in the risk grid format, and I'm going to propose that we move that to the risk grid and use Andrew's material as the basis of the model provisions. And the second item is based on something Carlo Piana mentioned. Carlo mentioned that, given we're using GitHub, once we have the document in play and we're saying this is ready, then it becomes a living document. No more versioning with different file names. There'll just be one document, the OpenChain model provisions, and we'll just edit that as a normal document from here on in. So those are the two things I'll bring up, more formally speaking. But Andrew, I was wondering if perhaps you might like to walk us through what you've been up to with this document and why.
Yeah, no, absolutely. Can everyone hear me okay?
Yeah, brilliant.
Good. No, that's great. I've just got my laptop back from being fixed, so yeah, hopefully it now works properly, which is great, and it does. So I'm now happy. Yes. So first of all, I'd like to thank everyone for their input in the last meeting because that was really helpful, and I think although people were very nice about what I'd done, they also highlighted a couple of issues with the previous drafting, which made perfect sense. So I've tried to address those. So to summarise the differences between version 0.4 and version 0.5. I've made it sort of more of a workflow now. So if you imagine the procurement process involves, you select one or more potential suppliers, then you go through a due diligence process to decide if that supplier or which of your suppliers is going to be the most appropriate one to provide the services to you. And then And then once you have that information, you make the selection, and then you're going to generate a procurement contract, which you will send to your supplier. So that maps into the work that I've done on the document that is now 0.5. So I have incorporated the first thing that you'll see, and I'll go through those in a little bit detail, but I'll give you the overview first. The first thing that you will see is a set of due diligence questions, and these are very much based on OpenChain. They will look very familiar to you. And then the and then the next document is a set of representations which are intended to be incorporated into whatever your own normal form of procurement contract is going to be. And I haven't done as much work on those because those are basically the document that we looked at last time. But the major difference that I've made is that I appreciated there's a lot of concern about this idea for the supplier information pack. And I think everyone on the call was absolutely correct in saying that this does not want to be something that crystallizes a particular specification for the software, which in itself becomes a contractually bound. So clearly, any procurement document for software, is going to deal with that in whichever way the parties think is most appropriate. So that there obviously there may be a very specific specification for the software, or the software may be developed in a much more agile way, and it allows for the specification to vary over time. And that's going to vary from contract to contract. And I think this is not the place to try to define what the software is. So all of that has now gone, you'll be pleased to hear. And the supplier information pack is actually more along the lines of exactly what it says. It's information about the supplier. So information about the supplier's conformance procedures, information about the supplier's policies, and so on. So basically, it's the information that you are entitled to request under assuming that the supplier is OpenChain conformant, the information that you're entitled to request from them about their policies and procedures, and so on and so forth. So I think that's much more aligned with what would normally happen, and it means that we're not trying to reinvent the wheel as far as the rest of the procurement process is concerned. So hopefully that makes people feel a little bit more comfortable, and I have to say, it makes me feel a bit more comfortable. So we'll look at that in greater detail in a second. So probably the easiest way to deal with this. So if you can just give me a second,
You want to screen
I will.
share? I'll make you co-host.
Yeah, brilliant. If you can do that,
Um,
that's probably the easiest thing to do. And then I can just give you a quick whistle stop tour of what we're actually looking at here. So, right, okay, I've got it up. So, whoops. Right, now where's Zoom gone? There is Zoom. Brilliant. Okay, so I can now share my screen, and hopefully I will share the correct window. Brilliant. Okay, so does that look like things that we might want to be talking about? Okay, so hopefully you can see this okay. So the first section is the due diligence questions. And I mean, I'm not going to go through this in sort of read out every word. But basically, the first question is to ask whether there is some form of certification or conformance assessment which exists already. Hopefully, they will say yes, and hopefully, they will say yes, and that's OpenChain. But if they do have any forms of certification, obviously, as the purchaser of their services, we want to know about that. So the intention is that question will disgorge that information, and then we go through to the set of questions which are themselves based on the OpenChain specification. So first of all, is there a policy covering selection, use, and deployment of FOSS? Question 2, do they provide training? Question 3, do they have a review process for FOSS licenses and understanding the obligations and conditions? And then some questions from that is, do they have a method of recording decisions? are those records attributable to specific versions or releases of the software? And then how long are those records archived for? Question 4 asks whether they're using any sort of software tools or services to assist with their compliance process. So in this case, what we want to know is just a little bit more about the technology around the tool chain that they're using. And that will give us an indication of how comfortable we are that they are going to develop in a way that we feel is going to get the result that we're looking for. Questions 5.1 and 5.2 are sort of more closely aligned with OpenChain again. So do they have individuals who have overall responsibility for a business license compliance policies, practices and procedures, but also do they have somebody who can deal with external queries that come in covering open source? Question 6 is basically we want an SBOM. And question 7 is really just sort of emphasizing that and saying, are customers provided with all the necessary compliance artifacts? And question 8 is also tied in with the OpenChain specification. So does the organization contribute to external open source policies? And if so, do they have a policy for that? So given that information, it should then be possible to make a much more informed decision as to whether that organization is appropriate to do the software development work that we want them to do. So are there any questions on that part? Nope, looks like a no. Excellent. So again, nobody will have had a chance to review this because I only supplied it to Shane yesterday, so it has not been around. Clearly, it's now on GitHub. So if anyone wants to raise any issues or indeed suggest changes, if they want to issue a request for that, then that's absolutely fine. So now the next section is the representations. Now, I've put them in as representations. The lawyers amongst us might also want them to take effect as warranties or indemnities or whatever flavour of obligation your local jurisdiction or practice favours. But I've just put them in as representations at the moment because that's more straightforward. Now, this may need a little bit of work on it because the intention is that this is a sort of hybrid document, and the idea is that it can be used for supplier companies that do not assert that they are OpenChain conformant, or they do assert that they're OpenChain conformant. And it's sorry, I'm just looking at Sebastian's comment here, which is great. Yeah, I think that's a good point, actually. This question as to whether we should be talking about specific types of tooling in there. I only really wanted to give that by way of example, so that the potential supplier knows what we're driving at. But it does sort of tend potentially to look as though we're favouring some suppliers over others. So yeah, I'd sort of welcome any more comments.
Andrew, maybe the way to solve that is to leave space for an example, but not provide examples, right?
Yes. Yeah. Okay.
So just sort of say the type of provider that we're looking for, SCA tooling, blah blah blah, whatever the magic words are, but not use the actual names, and then people can fill in their own preferred providers.
No, I think that's fine. I mean, I think I would be quite. I mean, certainly Fossology should be in there. I think it's reasonable to put in other open source projects, even if they're not necessarily fellow LF projects. As far as I know, LF gets on pretty well with the other foundations as well. So we're all performing the same job. But then we might just say something along the lines of or other proprietary solutions,
Right.
providing
Yeah, I think that's a
similar
good point.
SCA functionality or something along those lines. Yeah, maybe we can put something like that in. Super. So back to reps and warranties. Yeah. So the idea is here that at the moment we have a set of reps that can be used for any supplier, whether they're OpenChain conformant or not. What I may do is split this out into two versions. One which is aimed at suppliers who say they are OpenChain conformant, and that's going to be a little bit shorter because we don't have to go into quite as much detail. Because once they've warranted that they are OpenChain conformant, then that also implies a number of other things as well. But then for those that don't even necessarily know about OpenChain and certainly have not declared that they are conformant, then we need to go for the longer form of the representations, although they're still very much based upon the OpenChain framework. So I'm not going to go into these in great depth because we had a chance to look at them last time, and there's not much in the way of modification that I've made here. In any case, we're going to import the definitions from the OpenChain specification 2.1, just because it's convenient place to find some definitions, and they are not surprisingly they're aligned very much with what we want to achieve in this document as well. But I've put some additional definitions in there which are specific to this particular document. And as I say, the assumption is that this will be cut and pasted into a custom supplier contract that the purchasing company would normally use. And obviously, they would have to modify it accordingly. So 115 and 116. So I put asterisks against those because if the supplier is not warranting or not affirming or representing that they are OpenChain conformant, then there's no point in putting that representation in, so that can be deleted. And likewise, they won't have any form of conformance document, so we don't need to put that in. And indeed, they may say, well, we don't have any conformance validation document, but we have done an internal analysis and decided that we're conformant as well. So obviously, like all precedents, the intention is that these are sort of considered before they are actually used in the wild. So the following clauses map very closely against the OpenChain specification 2.1. So section 1.2 is all about the open source policy and process and so on. Section 1.3 confirms that there is appropriate access to the organization and to the individual roles that are needed to make sure that the conformance program runs appropriately and that they're appropriately resourced, etc. 1.4 covers the means of developing the appropriate bill of materials, and also looks at the requirement in the OpenChain that they understand common license use cases as well. 1.5 is about the compilation of compliance artifacts. 1.6 is if they have a contribution policy, it may well be the contribution policy just says we don't contribute to external projects, but that's still a policy, and that would certainly be conformant with this particular representation, but it may not be what we want to hear. That should be something that's weeded out at the due diligence phase. And ongoing obligations. So these are obligations that will subsist throughout the development process, And again, these are going to be tailored for each individual circumstance. But the idea here is that the customer, should be entitled to see verification materials, compliance artifacts at any point, throughout the development process, not just at the beginning or at the end, but any time on request. Obligation to ensure that the customer is informed if there are any changes to any of the information that they provided previously, or any of the policies or procedures, etc. And then 173 and 174 are sort of starting to get more specific. So I haven't suggested specific wording here, but it may be that the way the software is developed means that the customer actually wants to see the development as it happens in real time, and they want to be able to log into the repo and have a look and see what's going on. So we could put some sort of obligation in 173, and also in 174 we can put obligation in there so that the customer is given access to any queries that come in, any non-conformances have been found, what remediation has been carried out, etc. So just keeping an eye on the supplier's general conformance. And then the warranties and indemnities section, software bill of materials is accurate, and that covers each software bill of materials that is delivered, and that the software releases are accompanied by all the appropriate compliance artifacts. And we touched on this last time. This wording has basically stayed the same, although I've sort of tweaked it very slightly. An issue that I've had in the past is that the supplier will provide conformance compliance artifacts when the software is delivered to the customer, but the customer may then be passing that code on to third parties, and we need to make sure that the information available to ensure that that second distribution activity is carried out lawfully as well. I mean, obviously it is, it's the responsibility in that case of the customer to make sure that they are providing the appropriate compliance artifacts, etc., when they do an onward distribution. But it may be that it's, part of their contract with the supplier, that they want to make sure that the supplier facilitates that process for them as well. So that is the purpose of 1.8.2.2. And 1.8.2.3 takes that one step further, and it says that if the code is delivered to any end user, then appropriate compliance artifacts are provided as anticipated by the use case. So this covers a situation where, for example, the code is embedded in a mobile device. And in that case, the compliant artifacts are going to be different from if the binary is just supplied as a downloadable blob and is not actually sort of installed into the device. So it may be, for example, there's sort of GPLv3 code in there, and that may mean that installation instructions need to be provided as well. So the intention is that that needs to be captured. These clauses are likely to require more tweaking for individual use cases, but they're to give a flavor of the sort of obligations that it would be useful to have. And then 183, 184, 185 are really just a checklist to make sure that these sort of fairly standard items in procurement contracts are not inadvertently missed out. So I think that gives you a sort of whistle-stop tour of the work that I've done on this, and I'm very happy to listen to any comments that anyone may have.
So I think first of all, let's all repeat what Shane said already, which is thanks, right? Because this is a tremendous amount of work. I have more question for you, I think, that a comment at first. So I think these are very good. And I think what you said sort of early on makes sense. I think we might have to split them into, people that are OpenChain compliant versus people that haven't quite gotten the conformance in place yet. Do we think that this is a reasonable get in a procurement agreement or in the context of sort of a transaction. Is that something that you've seen sort of in your experience, people agree to all of these things? Because I'll be honest, so maybe and I'm going to answer my own question, which stinks. Sorry, but in my experience, I'm lucky if I get my list of open source components that I want and some form of no bad open source rep, right?
Yeah. Yeah.
And if I can get if somebody actually happens to know what OpenChain is, then I can try to get that language in there too. But so my fear is that there's a lot of really good language here. I just don't know if somebody who isn't familiar with the project necessarily is going to look at it and say, okay, right? How do I
Yeah.
how do I even approach this?
Yeah, no, that's a really good question, and I think, I mean, the purpose of this is, to try to be normative to the
Mhm.
extent of, I mean, I'm quite keen to get some these clauses or clauses like them to be released into the wild so that people actually use them. I mean, my experience has been that we've used the DD questions quite a lot, and the results of that have been sort of very interesting. So we haven't had anyone that has come back yet and said, "Yeah, we're open chain conformant. Don't worry about it." But we have had people coming back and said, "Oh, this made me look into open chain, and it does look like a good idea. And by the way, these are the answers to your questions," and they tend to be along the lines of, yes, we do have an open source policy. Yes, we do understand, basic license obligations. Yes, we do have some training. No, we don't have a contribution policy, and we don't have necessarily defined roles. It's just, it's all, just person X generally looks after the open source stuff. So they can normally, if they're a halfway decent supplier, they can normally answer about 80% of it in the positive. But what it does is it is very much sort of planting the seed in their mind that, this is something that we need to be doing. And then clearly, the next stage is obviously putting the procurement contract together. And at that point, what we're likely to be sending them is a fairly cut down version of the reps that I've just shown everyone. Because we know from DD that they don't do something, so it's not particularly helpful to be able to to try and put that in as an obligation. Um, so what I'm sort of very keen is to try to get these out into the wild, so people sort of start using them, and it just becomes the norm, and people realise, the simple way to deal with this is just to be open chain conformant, and then we've got everything to hand, and we can just hand it straight over.
Yeah, I turned my video on just so you could see me nodding. The diligence questions were, I think, very good. And I think for the reason that you said, and Sebastian, I'm going to let you speak in just a second. So I think that makes a lot of sense. My sort of one thought was, do we maybe take the provisions, the reps, and have two sets of them? Have the ones that we really care about, whether you're open chain conformant or not, and then have the others as a sort of more good to have. Like, for example, I certainly want the bill of materials, right? If
Yes,
I'm on
yes,
the procurement side, I care a little bit less about how you got to the bill of materials, right? In the perfect
yeah,
world, right, you'll be able to rep that yep, you got to it in the way that OpenChain prescribes you getting there. But if at the end of the day you can rep to me that the list of components on that bill of materials is true and complete, then we're in a better place than we could be if you can't make either one of those, right? And
yeah,
now I will
yeah,
stop
yeah,
talking so
absolutely.
others can.
Yeah, no, I think that's a really good point, and yeah, we should definitely sort of give some thought to that. So, Sebastian.
Thank you. So I was interested to know what the purpose of question 3.1 is in the context of license compliance.
Right. Okay, the purpose for that is really that a decent compliance program should have some mechanism for recording decisions, and so it's just really an indicator that the supplier has got their act together, as far as the process is concerned. If they don't have that, and it means that every time the same question comes up, they have to think about it, ab initio from the outset, then that's not particularly helpful. So it's more sort of an indicator that they do have some sort of sensible process that is methodical, and the fact that they record the answers means that they're developing an internal knowledge base, which is going to grow and improve hopefully over time.
Thank you. So I was actually thinking of it from the opposite perspective, which is that excluding security, would there be anything wrong from a license compliance perspective with a supplier that includes any open source software seemingly on a whim, but certainly not without any process, certainly not with a process? If they are complying with the license obligations, surely there doesn't need to be a requirement for new software to be vetted.
I'm not sure I'd be that comfortable, obtaining software from that particular supplier, because it sort of suggests that they haven't necessarily sort of delved down deeply enough to know necessarily what licenses are applicable to particular components. I mean, this is something that I have sort of come across in the past, and quite often, in this case, it wasn't with a supplier. It was a company that developed the software internally, and it was an enormous SaaS application, and they just had sort of grabbed useful stuff and mashed it all together without really thinking about the provenance. And it worked, and it was also largely compliant because they're not doing any distribution, so we sort of went in and checked to see whether there were any sort of AGPL or OSL or other licenses that might sort of cause deemed distribution issues. But we didn't feel particularly comfortable that they actually knew what they were doing from a compliance perspective. So I mean, theoretically, it's possible that they are completely compliant if they do that. We do have. I mean, some projects that we've come across, they just have a rule that says permissive only, and they only use they use sort of fairly well-known repos for obtaining all of their components, and they'll just say, as long as it's permissive, that's fine, and it makes life a lot easier for them. But they still need to think carefully about the obligations that attach to the permissive licenses, particularly Apache, sort of retention of notice files, and this sort of thing. So
Yeah,
I would rather see a more methodical approach, I guess.
I think the thing there is that, from a personal perspective, I would be comfortable in fulfilling the obligations of any open source license, and as a result, my process would be non-existent. And maybe that counts as a process in your eyes.
Yes, I mean, I think you just sort of have to explain that and then in the due diligence process that say, okay, well, does that work for this particular use case or not?
Yeah, it's just the wording there made me think, what about the opposite extreme where you have no requirements internally except that something's open source, and if you're comfortable with fulfilling those obligations downstream, myself, for instance, I just install stuff from Debian, and there's not much of a process there because I know that Debian already has no more obligations than I would be comfortable with.
Yeah, and I think that's a good point, and I think that's a process, and certainly, work that we've done. People have said, I mean, is Debian a trusted source of licensing information, etc.? Do we trust Debian's compliance? And the answer is yeah. I mean, anyone that's ever been on any of the Debian mailing lists will know that this is something that is considered in great depth whenever a new component is introduced into the Debian repos. Whether it complies with the Debian Free Software Guidelines and so on is thought about very carefully. So, and I think that's a perfectly reasonable assumption, and I think that's basically a process essentially. I mean, in a sense, you're outsourcing your compliance to another organization, but there's nothing wrong with that as long as you've made a sensible decision about that particular organization. In the past, we've said, yeah, Debian's fine.
Yeah, thank you.
Nicholas.
Yes, thank you. I just wanted to suggest where, because I agree, not all of our suppliers are necessarily prepared to provide the level of information that we're looking at in all these provisions. A lot of times, what we'll do is in our request for offer or invitation for potential suppliers to indicate that they want to work with us, be a contractor, et cetera. One of the questions we'll ask at that stage is, what is your level of familiarity with OpenChain? Have you never heard of it? Are you aware of it, but not yet compliant? Are you certified compliant? And then that might, we have 2 or 3 different flavors of the types of questions you have in the procurement agreement, depending on their level of familiarity with OpenChain and those ideas.
Yeah, that's a really good point. And to be fair, we do something similar. I mean, we have a sort of much lighter set of questions, which is really, have you heard of OpenChain? Because, you don't want to, if you're not careful, you're going to end up in a sort of antagonistic situation as well. So, you're going to, I mean, you are obviously testing a supplier and making sure that they are appropriate for you. But on the other hand, especially as if we're asked to do due diligence on suppliers, which we are occasionally, we don't want to immediately antagonize that supplier, especially because we're coming in as a third party and they already have some sort of pre-established relationship with their customer, and we've got to be careful about that. So I think from a sort of psychological perspective, as well as a time-saving perspective and everything else, it is very sensible just to ask some more gentle questions in terms of, have they heard of OpenChain? If they have, are they compliant, or are they sort of heading towards compliance, and so on? And then that will give you a better idea of the actual due diligence questions that you might want to ask. I didn't want to sort of overload this, because one of the things that we like to do when we're in that due diligence situation is to, if we find something that is potentially non-conformant, we ask the supplier what they would do about it. And if the supplier comes back with a sensible answer and says, yeah, okay, we acknowledge that that's possibly a problem, but this is the remediation that we might want to carry out, then that tells us an awful lot about that supplier. That's very useful information. So if we can tease out information that way, that's brilliant. But I think trying to build that sort of process, into what this particular exercise is probably overcooking it somewhat.
Yeah, thanks.
Yeah, no problem. Thanks, Nicholas. Right, super. Any more questions from you?
Well, I do have an addition, which is based on me goofing up a merge from Carlo earlier, where Carlo had prepared some material to put into the 0.4, and I've been too slow to merge it and then made the 0.5. So I just want to share something with everyone so they can see the commit. So in the chat, I'm just posting the commit the pull request Carlo sent in from 0.4. And that pull request, don't worry, has been merged with 0.5. So I'm just going to emphasize that 0.5 has it at the end. And I'll just put 0.5 into the chat again. One moment, please. Bear with me. Wait a second. Okay, 0.5 is going into the chat. And I will share my screen to show you what Carlo prepared. And this is something I think it was put at the bottom of the document in the risk grid format. So it's something that we can have a review of and decide what we want to do with it. And here we go, sharing my screen right now. So this is about the risk of a declaration that is just pro forma and how to verify. And Carlo, if I may, I just throw open the floor to you to cover that. Your thinking behind it and whatnot.
Yeah, thank you, Shane. It's pretty straightforward, actually. It follows on a discussion we had the last time we met on the opportunity to provide a sample audit close, so that the customer might have a way to verify the compliance. Here is made as a compliance to OpenChain. Actually, the general idea is to have it as lightweight as possible, and to also, of course, by a third party, preserving as much as possible the confidentiality of the non-public information gathered. And another idea is to have the possibility, once the audit is done, to receive the outcome or a report ideally by a third party qualified service provider that do the third party conformance check, and to have a report. And this report can be used in following closely following audit, so that you do the process once, and if you have multiple customer, you don't receive multiple requests, but once you have one, you can reuse that. And the second thing is that this can be used as a springboard for having a third party conformance certificate, by retaining the company doing the verification, but of course only after a certain time span has occurred, so that there is no commingling of interests between being an auditor and being a service provider. So I think this is just a rough idea I built upon a similar clause I'm using for data protection. You know, if you are a data processor, you might have multiple audits, so you can reuse and not harassed by many controllers, data controllers, to request an audit. This is and it's not an idea of mine. It builds on Amazon first data protection addendum. It's basically is a standard, pretty standard audit clause with some addition. Is a rough idea, not very thought through, but the general mode, I think is worthwhile. It's a document, mainly documental, and it can be done via expecting documents and also by interviewing people.
Now,
Question?
I just wanted to put a general question while others are mulling on this. Do you think that we should or could integrate this with the language format that Andrew has, or should we keep it in the risk grid format and look at merging that with the risk grid as one of the expansion topics that go there? Where do you think it
I think this is not for general consumption. I think many would have. I think this could be offered as a standard condition by a supplier for a relatively large supplier of technology or open source supplier of technology with the sufficient bargain power to impose sort of their own, when this is required by this even larger supplier. So, the general idea here is to but we do want an audit, and the supplier say, okay, this is the condition I'm offered for the audit, so that I avoid many audits on my technology. So it's not necessarily to wide adoption. So I don't see these audit clauses much much adopted by the large majority of customers.
Understood. And I mean, it is a missing piece. We didn't have that in there. And this is something that has come up, you know, over the years. People have said, what if someone what if someone lies?
Yeah. So I think it's nice to have addition for every standard language.
Yes.
People will accept it. I think its balance is not made for the customer or for the supplier. So it's made with a very balanced view, I think. So it combines it try to avoid it try to turn a hustle into a possible opportunity, especially for self-certified conformance. They can have an audit, so that's a hustle. But when everything is over, they can approach and say, "Oh, can we have this turn into a conformance?" I think that's for ex malo bonum, we say. It's from hassle or something, which is good. And also it avoids opening the floodgates for doing the same exercise over and over and over, which if hopefully if it's is widely adopted, or the concept of an audit is widely adopted, then it could be difficult to scale up. This way, it is more likely to scale up.
Thank you, Carlo. Makes a lot of sense. I was just wondering if anyone else had any comments on this edition at the moment. Okay, if there's no immediate comments on it, it has already been merged in 0.5. And really then we're just thrown to a question, which is basically Andrew's structure goes from the beginning of our document with this sequence of questions and these provisions until we move to a changeover of optional model language related to these ISO standards in the original risk grid format. And one thing I wanted to propose was that we have a look at whether we take the risk grid format items and put them into the risk grid. So then we have Andrew's template as the basic on-ramp, something which has already in some ways, I think, been discussed in this call, where people are saying, should we break out more of the language? And then the initial model provisions document is the on-ramp, and the old risk grid document begins to contain not just the generalized risk allocation that it previously had around open source, but more and more specific language examples related to our ISO standards. And this, you know, may or may not include moving Carlo's suggested addition to that. But first, I'd just like to raise the topic of moving the risk grid format stuff into the risk grid, which we then subsequently update and restructure to make sure that it's relevant and ordered in a way that's a super useful, larger reference. And then have Andrew's stuff as the smaller on-ramp, which is, you know, just a couple of pages. Yes, and with that note, I'll just let it hang for a moment. And Carlo has a proposal for a workflow.
Yeah, I don't want to interject just now, and that can be left at the end of the discussion because it's just a way forward. So I don't want to jump. But if we are finished though, I can very quickly suggest how to bring things forward.
Okay. In that case, I'll just show people what I suggest doing, which I would do in this call, which is essentially at Andrew's end, snip out then the risk grid format language, starting with this issue, inclusion of OpenChain ISO 5230, snip out all of that and put it into the risk grid, which is here, in a new section, just ISO 5230 and ISO 18974 topics. And that will be my suggestion for what we do now. And then we have the basic model provisions in document 1, and we have a much larger, bigger document with lots of stuff as document 2. So you can grab document 1 to get started, document 2 to go into the weeds. Is that proposal, acceptable to people? Would that be something we could do? And then we could aim to lock down the document originating from Andrew in the near term, and then move to making the risk grid updated and modernized as a larger compendium of risk allocation and ISO 5230, 18974 topics. Okay, I have 2 positives on that. So given there's no objections listed, then that is what we shall do. And before we move to Carlo's workflow suggestion, there is another suggestion I had, which is when we move this document and away from the historical artifacts we've had in the first few drafts, so people could follow along in this process earlier, when we move to the living document, declaring, let's say, the smaller, lighter version ready, then we put in some language. This isn't intended to be the language, but I just put it in the chat. Some language saying that the published document, the finished document, is a living document. It's not going to be a version document. It's going to live on GitHub, and that will just keep iterating as people contribute over time. And presumably then we do the same thing with the larger compendium built from the risk grid, which is a deeper dive into more examples. And then we'd end up with 2 published documents that are permanently living documents, very clearly referenced documents because they're not codified as ever finished, which would allow lawyers to dive in, thumb through things, get inspired and leave, and perhaps even leave comments for improvement. Now, this is based on a suggestion from Carlo, and I think it makes a lot of sense, and it makes editing a lot easier, and it would mean that things like my goof up between 0.4 and 0.5 changes wouldn't happen in future. There's a thumbs up from Jimmy. So if there's no objections, then when we hit publication on this, let's do that. Okay, and because we're getting very close to publication, and Andrew, correct me if I'm wrong, but unless there's any objections or changes necessary further, we're very close to locking down and being ready to go, right?
Yes, yeah, I feel comfortable with that.
Okay. And naturally, everyone, you can object either here or with a mail or with an issue, but yeah.
Can I just also report a little bit more news related to this as well, potentially?
Yes.
Which is because Tim and I are currently working with LexisNexis, and we are updating their open source note, sort of practice note. So this is their professional development database that practicing lawyers have access to on various topics. And so we've I've just actually done sent them a sort of drafted them a note on open source in general. There's quite a lot about OpenChain in there. But one of the things that we've said, they want us to produce a bunch of precedents for procurement and for due diligence. We said to them, well, we're happy to do that, but only if we can do that on a non-exclusive basis, because these precedents that we want to make available elsewhere. And they had a little sort of thought about that and said, well, no, we can't do that. But what we can do is we're quite happy for you to put links to industry established precedents within the text that you're providing us, so that users of our service will land there. So what I'm quite keen to do is that when we're comfortable that these precedents are in the form that we want them to be, is that then we can ensure that they're sort of easily available to people who are coming from the LexisNexis service, and it might even be a question of putting a sort of separate link in that says, "Hey, you've just come from LexisNexis. Welcome." Give them a little bit of a sort of show around and say, "And this is the precedent you want. Click here to get it. This is how you use it. This is what it's intended for," so that it's more of a sort of seamless and friendly experience for them. But I think that demonstrates that there are ways that we can try to make this sort of process more industry standard, and that I think is going to drive quite a lot of engagement in terms of OpenChain in general, hopefully. So fingers crossed on that one.
Absolutely. And I have a bit of side news as well, in that we're going to have to change the language from ISO IEC DIS 18974 to simply ISO IEC 18974. We've passed the ballot and publication is pending at any moment now from ISO.
Fantastic.
Yeah, so we have an
Hey.
security. We are now, after transitioning from a project that has made a license compliance standard into the project that makes the open source process management standards. And the question is, what next? Which makes this model procurement language more essential than ever. Okie dokie. I believe the last item on our horizon, apart from Andrew's exciting news, and I guess the relatively exciting news, we now have a second ISO standard, officially after passing the ballot, is Carlo's suggestion for workflow, which is obviously going to be critical moving forward. Over to you.
Yeah, very simple. Because we are based on GitHub, it would be silly not to use. For those who are familiar with that, the facility, I don't know how many have experience of contributing to projects with GitHub, GitLab, or simply any other Git-based platform. They always have a workflow. So, and the workflow is basically based on branches. It can be very, very complicated, but I don't propose anything like that. I propose that the main or the master, I don't know how you call it. Anyway, the main branch remains untouched as much as possible and only receives the new versions. So any new version is the same document receiving a new merge from an above branch. And there is a development branch where people contribute new additions through either opening a sub branch, so a sub branch, or having a pull request from their own fork. So the workflow is there is somebody in charge of accepting contribution. These contributions are live into a development branch, and when they are sufficiently accurate, sufficiently fixed, they go into a new version in the main branch. So ideally, you have three levels of branches. One, the main with all the versions. By the way, Git and GitLab and GitHub can label versions that you easily go back in history to verify the various versions. A development, relatively stable branch, and as many features branches, i.e. For instance, my addition is not my proposal is not a very set in stone. So somebody else could want to improve or tweak, and when this feature on its own branch is ready, it goes into development, so people will see how this pans out. And when it's sufficiently agreed, it goes into the main branch. So this way, also we, as many people here are lawyers, get used to how the project, the workflow of the projects, of the software project develops through time. It's very simple, but it sets the mindset of contributing to a development cooperative project.
The basic idea seems to work for me, depending on how technical our audience is. Would it be okay to give guidance to people that they can open an issue, if they're not sure what to do, open an issue, and we'll lean in and try to help them?
That's an I mean, you can offer help to people and have a workaround, but I would invite everybody to at least try. Since we are working on a protected environment, there is nothing you can screw up. So the worst thing you can do, you could do something that can be undone. But I invite people not to be lazy and to try and contribute. If that's unsurmountable and people say no, that's not something for me, then opening an issue is the another way of doing. So you open an issue, put the language you propose, and somebody I could help with that. I've quite experienced in my firm and in the project I'm contributing to, of showing how it can be done, so the next time you can do it yourself. I think it's a balanced proposal and educational to some point.
Anyone else have comments on this? All right, if there's no further comments, then it looks like that is target guidance for how we will try to message updates going forward. Okay, and with that, we're approaching the close of the meeting, but not before there's an opportunity for any other business. Does anyone have any comments or suggestions they'd like to make about this or anything else to do with the legal work group? All right. If not, then it is time for our close of meeting. Everyone, thank you very much. Special thanks to Andrew for an incredible contribution, and to Carlo for not only contributing, but also trying to shepherd us towards better workflows, which of course will be necessary given that with all of these ISO standards floating around and the fact this model procurement language is likely to go deep in the supply chain and inspiring lawyers around the world and being translated and shared onward, we should obviously try to have the most sensible workflow possible. With that, thank you all. Have a beautiful day and talk to you soon.
Thanks, everyone.
All right. Bye.
Bye-bye all.
Bye bye.